Hi, welcome to another episode of Dirt to Dollars. I'm Chris Cox and your host for today, and I'm joined by Greg Reaume. How you doing, Greg?
Good, good. Thanks for having me on the show.
Yeah, for sure. So, as I was kind of explaining, earlier today, and throughout, you just asking me why I invited you onto the show, like, what's it all about, right? So, the premise of this show is to look at the inner workings, the details of how people who are trying to make money off of property do it. From the beginning standpoints of like the stuff that I usually work on, which are more of development permits and compliance, to what you do, which is more on the contract side of making sure that your clients are staying safe and they're not liable for things that they shouldn't be.
Great. Yeah, let me just jump in. That's exactly what I focus on is construction contracts and litigation, as well as real estate. And I've been involved with a bunch of projects that have gone into litigation and turned out not profitable. So what I'm hoping to do here today is give some real concrete advice at how folks can make sure their projects don't fall into those pitfalls.
Yeah, great. So, based off of what you just mentioned, giving some advice, how about we kind of frame things out as like, what are your top three sort of topics or issues that you want to share with folks, and we can kind of go into a little bit more detail on each one.
Okay. Um, so I typically focus on the part of the project that comes after the permitting and entitlement. And what I find often is developers have gone through an extensive, time-consuming process to get to the point of construction, including through their drawings and everything else like that. And by that point, it seems like there's uh, a little bit of exhaustion. And so the construction contract oftentimes can be an afterthought, or they can just kick it off to a law firm without thinking much about it. And that's the point that I want to enter into here, and just say don't make that mistake, because you can definitely sink a project through a bad construction contract. Um, so taking a look at construction contracts, there's a couple different areas that I would look at. One is payment terms, two is change orders, schedule, indemnification. Those are probably the main ones. There's obviously a lot of other areas that we could focus on. Um, but those are ones that I could touch on, in a concrete way during our talk if you want.
All right. So we had change orders, we have scheduling, and we had, what was the last one you mentioned?
Payment terms.
Payment terms. Let's hear it. All right. So Uh, I could definitely see some parallels with what you're talking about with, because we essentially end when you start. So, and a lot of what we do is when we're going through a permitting process is anticipating what will happen on the ground later. And, throughout my career, what I've noticed, I started as a landscape architect and planner and worked many years in consulting. And what I have found is that a lot of times people just don't really connect the dots. You've got somebody working on a CEQA document or a land use permit or, even a building permit, but they're not really thinking about what happens after they're done and how does their work affect the next guy or the end guy. So I think that that's really interesting. So you could kind of dive into change orders a little bit more. I mean, I know what those look like on my end when I
Yeah.
issue contracts.
Yeah, and I do want to touch upon one concrete nexus between the work that happens before the construction and what goes into the construction contract, and that is hazardous materials and unforeseen conditions on the site. Um, so there are clauses in every construction contract that address hazardous materials, and the typical setup is that the owner owns those hazardous materials unless the contractor brings something on site. So it is important during the entitlement process or during the site investigation process, to ensure that the owner gets a comprehensive view of what hazardous materials might be there. Because if they don't know what they are, they encounter some other ones, they're going to be issued a change order as construction progresses. Um, And as you know, change orders are just a change in the terms of the contract that come about if there's a unforeseen site condition or if the plans change, something to that effect. And something, so this is going to backtrack us a little bit. Something that's very important at the beginning of the project is that the plans and the scope of work be tightly specified. Because to the extent they're not, there's probably going to be change orders or there's going to be arguments over change orders. And every project is kind of this, it seems to me, this push and pull between what a developer wants to do, like a big picture, and what's actually available within its budget. And in trying to negotiate that, oftentimes details get kicked out or missed, and those gaps are going to gaps in design or specification, whatever it is, are going to emerge as a change order later on. So at the beginning of the project, the owner wants to make sure and understand where it can ameliorate that risk. So it should be thinking generally, if I have a problem down the line after we start construction that causes a change order, I should be looking at the architect if it's a scope gap thing, like if it wasn't specified in the plans. If it's something that should have been accounted for, then I should be looking at the contractor. And there are specific clauses that address that. So typically in a construction contract, you'll have a clause that says any gaps, the amount that you're paying for construction includes inferences as to any design that are reasonable, right? So the plans don't have to be exactly specified, but they have to be, let's say like 95% there, and then the contractor is expected to make that 5% jump by the terms of the contract, of the typical contract at least. And to the extent that they can't, or that gap is too big, there's going to be there should be a change order issue for that gap, and that will increase the price and increase the contract time.
Yeah, that makes sense. So there was a couple of things there that kind of popped in my head as you were talking, and I think kind of two primary avenues where you could end up with a change order. The one is hazardous materials or something similar to that, like that on site, and then the other is a design gap in the final drawings that or specifications. And so the first, I mean, I can see exactly where this has happened in my own projects. For example, the hazardous materials part, oftentimes we're required, or a client or developer is required to get a phase one or possibly even a phase two environmental site assessment on a project. And so is that kind of incorporated into your hazardous materials thought process?
Yeah, you can. Yes, it is. I mean, it depends on how big the project is and how polluted the site is. So, the typical hazardous materials clause is down in their form contract, developed by the AIA, the Institute of Architects, American Institute of Architects, and also by the AGC, Associated General Contractors. Um, so they're the AIA form contracts and the consensus docs, which is the AEGC form contract. Those both have hazardous materials clauses in them. And those form typically like the template for almost all of the contracts in the nation. So most attorneys will just cut and paste those clauses and then modify them from there. And the short version of that is that if there's hazardous materials on site, work stops and the owner is responsible for remediating it. Now, to your point, further up in the contracts, there is usually an incorporation clause that defines which reports are included in the contract and which reports the contractor is expected to know about. So if it's a big project and there's an extensive pre-construction planning process, what a smart developer will do is give all of its environmental reports, all of its planning reports to the contractor and tell the contractor to review them. Then then in the construction contract, it will say, you've reviewed all these reports. So you are aware of everything that's happening. So if these reports mention anything about hazardous material, now it's on the contractor. So they can shift the risk for that hazardous material to the contractor in that way. There's typically an argument over whether or not that's allowed to happen. So if I'm advising a contractor, I'll often say, you're not incorporating any of this stuff into the contract, right? Unless you go out to the site yourself, do the testing, and you know what's out there. But if you don't know what's out there, then don't do it. But if an owner is looking to offload risk, and you typically find this in public agencies, they will say you got to take it. You have to take this risk, and it could be a big risk because like with the PFAS stuff and all the newer stuff coming out, and there's also new regulations coming out about where waste can be taken to once it's off hauled from a site, and that those represent huge, what can be pretty big cost. And so the developer has to think about where they're going to push those costs. And again, to kind of back up from a more high level in terms of contract negotiation, something that developers should be thinking about, developers and contractors, is they obviously want to minimize their risk, of change orders or of finding hazardous materials or of anything else. And typically they will do that, at least in the public context, through extremely onerous contracts that push everything down onto the contractor and then to the subcontractors, right? They try and push all the risk down to the smallest player. That's not a great way to negotiate a contract or start a project, because you're hoping that the smallest tier of folks, and I mean smallest by has the least amount of money, or maybe the least amount of years of business, has enough insurance to additionally insure you up through the chain if that's happened. It also makes the relationship a little bit adverse. So in some ways, I often see developers thinking, it's more the developer's attorney who are thinking they're going to push all the risk off the developer as much as they possibly can. But what they're not seeing, the unforeseen side effect of that, is that there might not be any money there to that place that they think there would be money coming from. And it will raise the cost of the project, because a sensible contractor will say, that's fine. You can make me responsible for everything on site, but now I'm going to have to add another $1 million here to the site, right? So there's a cost and a benefit to trying to push the risk too much for unforeseen condition or design, unforeseen conditions or design gaps.
It sounds like you are a little bit more preemptive about how you help your clients get into these contracts in the first place so that they avoid things like that. Because, I mean, I feel like once you actually enter into a contract, sort of buyer beware in some ways, because, something could come up after the fact and that's much harder to deal with. But if there's full disclosure on both ends at the beginning, then there would be a better negotiation.
Exactly. Yeah. Now, what happens, and you might have seen this yourself, what happens often is a developer will have a bunch of reports, and with a short amount of time, attempt to put them into the contract and say, you're aware of all these reports. And so for example, I was working on a project where they must have incorporated at least, 10 reports, let's say, at least. And each of those reports within them incorporated reports, some of which were decades old. So the total corpus of information that was incorporated was massive. And the contract just said, you're aware of all this, you take all the risk for all these reports, you know? So there was a huge fight about that, because it, from a practical standpoint, it didn't make any sense. Of course, the contractor and all the subcontractors and everyone else could not have read all that information, right? And neither could the in that scenario, it was a public agency. Neither could the public agency. So there was a big problem there because no one wanted to take on that risk, and it was exacerbated by honestly the owner's attorneys being inflexible. And so there should be some control of the attorneys to say, look, we understand that there's risk here. Let's do what's reasonable and what makes sense for everybody involved, to get the project moving forward.
Now, my follow up sort of comments about that is when you start getting into design mode, you would expect designers, including architects and the multitude of engineers that are involved on any of these projects, to review that work and incorporate those studies into their design and specifications. So by the time a contractor gets that information, they should be able to rely not just on the study itself, but the final design. So, for example, I mean, I have two things: hazardous materials and geotech just popped into my head, and studies inform design. then design is supposed to mitigate for whatever might happen that's, negative about those things. Whether you have liquefaction with your soils, or you've got a pile of garbage that's, 5 feet down underneath the ground and nobody knows about it. Whatever it is, then that design should be able to inform the contractor at the end. So, I mean, I also feel like that there might be in some of these scenarios, maybe also a gap in the design.
That's exactly right. And under the law, under what's called the Spearin Doctrine, if the designs that have incorporated the studies, that respond to the studies and incorporate those findings from the studies, leave something out, the contractor is entitled to a change order because it can't fill in gaps of designs, does it, because it doesn't have a design license. Um, However, what you commonly see is, despite that reality, the contract negotiations will start out with developers saying, here's a design. If there's anything we missed, it's your fault, right? And to the contractor. And so that sets up an expensive and time consuming negotiation. And it's questionable how effective those types of clauses are. Um, but that's exactly right. That's how it should work. It doesn't always work out like that in practice, depending on the attorneys that you get.
So when you advise your clients, how do you write that contract? Let's say that your client is more savvy than the average client that gets into some trouble, and so they review the design work, they review the studies. How are you setting up that contract to help them maybe get it, but maybe also avoid bad contracts and negotiate good terms?
So it depends on who I'm representing, but my general approach is to put out on the table, as in a more collaborative manner, the risks, the big risks for this particular project, and then address those one by one. I think I think there's a good chunk of attorneys that operate like that. There's another chunk that operate off of, kind of, you have the contract, you have your typical clauses in a construction contract. And it's the same with any kind of body of contract. Say it's a purchase and sale agreement or mergers and acquisitions, whatever it is. In a project construction contract, you're looking at liquidated damages, indemnity, payment provisions, change orders, dispute resolution, termination. Those are the main, and the contracts and the documents that are incorporated into the contract. Those are the main areas that there's going to be negotiation for. Your old school kind of attorney is just going to push it on each of those areas, an entirely one-sided approach, right? And if they're on the owner's side, their tactic is going to be, look, if you don't want the project, then fine, we'll find someone else. That's going to be the way they approach it. I think a better approach is to say, let's look at the body of risk that we have and how it can be allocated, between the parties, right? And there are ways to allocate risk that make sense. There's insurance, there's indemnity clauses. You can look at the business entity structure of each party. So there are ways that you can ameliorate the risk as best as you can. And you should be taking that into account as you negotiate the contract. So I will say, for example, here's a simple example. I was just doing a contract the other day for a county in a large city. And the owner's attorney was with the indemnification clause, was trying to indemnify, it seemed to me, like the entire city, you know? And I had to have a conversation with him to say, why are you pushing for this? And the answer effectively was, because we can and we should, and I should say, every attorney is under an obligation from the California rules of professional conduct, which regulate the ethical practice of law, to zealously represent their client. So there is a sense that you're supposed to push for everything you can get at all costs, right? Um, but after we talked it over, he started to realize that it just didn't make sense, because we were in the position like, well, then that's okay. We'll just walk away from this project. There are enough other projects going on right now that we don't need this. But my approach is to say, what risk are you trying? Who is worried about getting a claim that they would need to be indemnified from? Okay, the county. And then who could sue the county if there was a claim, because then maybe they should also be indemnified, right? So now we've got maybe 2 or 3 parties that have a real risk of being sued or wrapped into a lawsuit or being damaged. That's fine, because insurance will help us to cover an incident that might require that indemnification. But if you're going to make the contractor indemnify a list that's 30, 30 parties long, there's not insurance that's going to cover that. That's not good. That's not a practical approach, right? And so let's look at realistically what you need, and then realistically what we can purchase from insurance on the market that might cover that. And if those match up, then everybody's happy, And it's that type of approach. You've got a risk. Can insurance address it, or is it something that is not actually that big of a risk? Because maybe, let's say, worst case scenario, this risk might take out a company, but the company is an LLC, and the members won't get hit with any liability, and that's all actually the owner's worried about. Doesn't really care about the property itself. You find that sometimes in real estate with single purpose LLCs. So that kind of way of balancing the risks and talking about it like that is an effective negotiation strategy.
Well, you bring up the LLC, and that strikes me as an interesting point because developers usually use LLCs to compartmentalize their development projects so that in worst case scenario, they can walk away and it doesn't affect the rest of their livelihood or assets. But what's interesting about what you're saying is that the developer at the end of the day is the one that owns the project. So if they push hard enough on a contractor, even if after they have signed an agreement with them, ultimately, if it's too risky for the contractor, I mean, they can walk away from the project a lot easier than the developer can. So who's really carrying risk at the end of the day?
Yeah, that's a great question. I've thought about this a lot, and I've seen all sides of it. I was representing a hotel owner in LA, and I felt like we were giving the contractor a great deal. We had early completion bonuses, which is a way to incentivize the contractor. We had cap on damages for the contractor. A lot of stuff that was you don't typically see in the market. But that contractor had a bunch of work, was a great contractor, and was like, "This is still too much for us." So too much risk for us. So we're walking away from it. So contractors, will walk away. Um, I think if there is too much risk. I think as to the risk allocation in general, which is what you're asking about, between a developer and a contractor. What I've often seen in public projects, and this might make sense in the public context, is that public entity attorneys, the owner, the law firms that are typically represent public entities, will try to push all risk onto the contractor. And in some ways that makes sense because the party at risk really is like the public, broadly speaking. So you don't want a project to go south. If one contractor has to go bankrupt, that's better than all of the taxpayers getting hit with some massive disaster on one hand, right? On the other hand, in the private context, I think the risk should be borne by the developer because that is the game, right? The real estate game is you make a bet, right? You don't have much skin in the game, like you're getting other people's money to put into it. You didn't, so you're kind of assembling other people's money and trying to get this thing going. And that's the job is assessing the risk from the outset, and you're taking those risks. That's the whole point of what you're doing. The point of what a contractor does is to build things, right? They're not out there with, folks assessing the risks, like seeking deals and stuff like that. They're trying to build stuff and get paid. So it's in my mind, it's not efficient or doesn't make much sense for a developer who's been trained in how to evaluate risk, and a contractor who has not, he's been trained in building to try and push a bunch of development risk onto the contractor. So if a single purpose LLC fails, and I do have a case like that right now, in Los Angeles, the risk is appropriately placed on the contractor. And at least in this case, once you get involved and you see what the developer was doing and the assumptions they were making, you kind of think, look, man, if you're gonna make these crazy assumptions and make these huge bets, other people shouldn't have to bail you out. That's if it's a bad decision, it's a bad decision. You got to own that. Not the folks who are out there swinging hammers, expecting to get paid, doing just doing what they're getting paid. if that makes sense.
No, it definitely does. And I feel like I could talk another half an hour about specific instances where that, has would make a difference one way or the other. But in the interest of time, let's move on to your next topic, which was the scheduling of a
Yeah.
project.
Yeah. Scheduling is often very important to developers, usually because they have loans that are going to come due. They need to get things going before those loans are due. I'll tell you one tidbit that seems like a lot of folks don't know. Um, the There's an interplay in schedule in schedule contract clauses between liquidated damages and a waiver of consequential damages. So just in case folks don't know, a liquidated damages refer to the contractor being assessed damages for every day past the completion date that the construction project date. So, if it's supposed to be done on July 5th and it takes them until September 10th, then that every single day over July 5th that it takes the contractor to finish the project, they're being hit with $1,000 a day or $500 a day or whatever the damages are. Those are called liquidated damages. Um, those are common now in construction contracts, and only if there is what's called a waiver of consequential damages included alongside that clause of liquidated damages. And the waiver of consequential damages, what that says is, look, we will accept this risk of liquidated damages as long as we get a waiver of all other types of damages. So let's say that the developer has a loan that's coming due and the loan is due on, July 5th, and they've got to start making money renting out that property on July 6th to pay this loan back. But the contractor doesn't finish. Now, if there's no waiver of consequential damages in the contract, the developer could go after the contractor for all the lost rent that it has had until the project gets finished, right? So that's why the contractor usually requires a waiver of consequential damages. And they say, look, you hit us with the LDs, the liquidated damages, so we can assess our risk that we know how much risk we have for every month that we're late. And in response, we will get a waiver of all of the damages so we don't have this amorphous amount of damages. An interesting tidbit that comes from a case um, in on the East Coast in Atlantic City. There's a huge contractor called Tudor Crane, and they were building a casino. As a construction manager, they went over schedule by, I think it was like 2 years, like a very long time, and way over budget. And they had a liquidated damages clause, but they did not have a waiver of consequential damages. And actually, I don't know if they had a liquidated damages clause, honestly, in this case, but they did not have a waiver of consequential damages. So they went to court, got sued, and the casino said, look, if you had finished this on time, then we would have been making this much money. And they were hit with, I believe it was $300 million, and their contract was only $65 million. So they got a massive judgment against them. And ever since that case, every contractor has required this waiver of consequential damages because that amount, that 300 million, that's what's called consequential damages. If you can fit anything into your damages calculation if you are in a lawsuit, like that. So that's the scheduling tidbit I have. The other thing I'll say about scheduling, because this is often the source of disputes, is it again goes back to just being reasonable. If there are real deadlines or real timelines, meaning that if there's funding associated with, or if the developer is subject to other penalties or something like that, then they should be letting the contractor know that. And it's in their best interest to do that, because if the contractor does know what those penalties are, then that kind of puts them on the hook for potential damages. You could make that argument later down the line as an attorney. If there isn't something that's pressing, then they should. From my perspective, I always counsel developers to look at what's going to get you done quicker. Are you going to the relationship you have with the contractor, or trying to have them meet a deadline that isn't necessary, right? Because oftentimes, and sure this, these delays in projects can be traced back to disputes between upper management. Sometimes they can be traced back to, let's say, supply chain disruption or people not being on site or strikes or if there's a disaster. But oftentimes those things can be covered by insurance or they're rare, like strikes are rare or they're clear enough where one side in the contract will say, yeah, that was my rip. Like a labor strike. If it's a contractor, it's like, that's on me. I accept that rip, you know? Um, so if, if there's if there's a clear risk that can be, there, that can be allocated one way or the other. But if there's not a clear risk, then it usually comes down to a dispute between two management personnel. And that's something that, you know, you can't address that legally. That's a simple personality and project management problem.
I definitely would agree with that last point, but I'm also, as you were talking, I was thinking about what other types of delays would come up on projects, and particularly with construction. One of the big linchpins is agency inspections and compliance. And sometimes, I mean, I remember a project that was delayed. The same project was delayed by 7 months by American Water because they just didn't respond. And then later, the fire department decided that they didn't read the plans correctly when they were going through permitting, and they needed another report that costed 3 months of time. And that amounts to at minimum rent. Yeah, nothing
Yes. Yeah.
as well as
That
operations.
Yeah, and that gets back to the change order issue. So those are real and big risks on a project, especially the fire marshal, especially elevator companies. Getting out there and doing stuff. And in the contract, typically, the way it's written, if there's a change that's beyond the contractor's control, or if there's a reason for delay that's beyond the contractor's control, they're entitled to a change order for that. And let's say the fire department or building inspector or something like that. If there's, and this is more general, if it's an agency representative or an approval that the developer can have some sway in, maybe they know people in city council or something like that. From the very beginning, I would recommend that they be thinking about those connections because it's exactly like you said, some of those things can take a really long time. Now, on the contractor side, and this should be written into contracts as well, if there are time risks that clearly are within the contractor's domain, for example, long lead time for equipment. So electrical equipment right now, or at least a few years ago, was impossible to get big. And by that I mean big transformers and things like that. So lead time would be like a year out. Um, in your construction contracts, you want to say if you're the developer, that's on you. I don't know what the lead times are. You're in the market, you take that. And if there's a delay on that, then you're going to be hit with those LD. And the contractor is better placed to try and shorten that time frame in that context than the developer is. But some of these inspections, I had one project. This was now a long time ago, and I think this is because there's a dispute between the building owner and the construction company. The building inspector and a person in the construction company. The building inspector came out, looked at the wiring on this hotel remodel, said it was wrong, and told them to rip it all out because it was the wrong color. Literally said it was the wrong color. So there was a huge argument, and the contractor ended up changing all the wiring. And months later, same inspector comes out and says it's the wrong wiring and tells them to change it to code compliant and back to how it was. And so, as you can imagine, that didn't turn into a lawsuit, but it almost did. Now, and that was in Los Angeles, in the same city, I knew an attorney who left law and started a copy shop. And he had a problem with an inspector trying to get,
Too much
I can't
stress.
remember what it was, but yeah, trying to get his project approved, and it was giving him trouble. And he didn't waste time. He just called his city council person. He's the project owner, his attorney, and he chewed him out. He was like, "What is the deal with this inspector?" Because the inspector really was not doing the right thing.
Yeah.
And yeah, that got passed quickly. So it goes back to the same kind of general concept. Think realistically about who's better positioned to address the risk, right? That it's better to say, look, if you're the developer, you know people, you always involved with planning, you've got connections. Well, you should be thinking ahead and trying to plan for those types of risks that you can ameliorate. If you're the contractor and you know the market for construction materials and labor and stuff like that, that's your risk. and those things should be allocated through conversation in the contract negotiation process rather than trying to shove all the risk in one party or the other.
Oh yeah, oh yeah. I mean, the other side of the coin is the contractor has to take on the risk of providing professional work so that it meets inspection requirements. So
Right. Exactly. And that is so typically in the contract, you will see a couple different phrases that touch upon something like that. Every contract says you have to build something to workmanlike standard, and that catches you right there. So you can't build anything that definitely not safe because then you'd be in violation of statutes. But better than that. Um, and also in a contract, you'll usually see this gets back to the scope gap conversation we were having earlier. A phrase that says something or clause that says something like if there's a gap in the plans or if there's confusion about a certain element that's to be built, then the contractor should assume that whatever that material is that needs to be built is the highest and best material. And a simple way to illustrate that is let's say um, you've got door handles, right? And you can go to Home Depot and buy the cheapest door handles at Home Depot because they're not specified by the designer in the drawings. That clause is meant to say, if it's not specified in the drawings, then you've got to buy the most expensive door handle, right? And the idea there is to prevent the contractor from getting the cheapest the cheapest materials that they can find for anywhere in the contract where things aren't specified.
interesting. Okay. So how about we pull payment terms into that conversation? Because I really, even though they're seem like three separate topics, they're really not. They're all kind of
Right.
intertwined.
Yeah, they are interconnected. I think, and this is where another point of advice for the audience, the contractors usually run on thin margin. And so payment is um, like critical to them, more so than I feel like what happens is developers usually have a chunk of money or the ability to get money, whereas contractors and especially subcontractors literally don't. And so there is a game that gets played, and this is the interplay of the payment process and change orders, where the developer will hold back payment because they're either trying to keep it in their bank account and get interest on it, or they think that that will be motivating to the contractor, like a negative reinforcement or something like that, um, and hoping to get more performance out of them, and that almost always backfires. Um, so in the payment, the way that you can do that though, if you are a developer and you want to have power to do that, is in a payment clause. Usually there's a long list of requirements for a contractor to get paid: a progress payment and then the final payment. And there's also retention. Side note, a new law that came out this year is that you can't hold back more than 5% of each pay application for retention. Didn't exist before. People were holding back 10% or a lot more. So in your typical payment provision, it will say you submit a payment application and you have to submit like a laundry list of things, an affidavit saying that these are all right, that you swear to the penalty of perjury. Of course, you have to submit your lien waivers, so you can't lien the project for that amount. You have to submit any certifications. So anything that could be required for the owner to verify or be comfortable that the work is done to that point has to be submitted. Now, it usually there's a catch-all clause in there that says something like, and anything else the owner requires to establish that, the work has been done, something like that. If you're kind of savvy, or, and maybe not such a good person type developer, then what you can do is you can not pay based on saying, well, you haven't provided me all the documentation that I need for me to authorize this pay application, right? And so you can keep delaying payment by asking for more and more documentation. Now there's risk to that because in California, there's prompt payment laws, and the prompt payment laws say that after you receive a payment application, payment is due in some amount of time. I think it's 30 days for progress. And if you do not pay within that time, you accrue interest on that payment at 2% per month. And if there's a dispute over whether or not you should have paid during that time, whoever wins pays the other side's attorney's fees. So it's a risky game to try and withhold payment. But you can still do it as long as you have a good faith reason for withholding payment. So if I'm representing a developer and they're trying to withhold payment for whatever reason, the first thing I asked is, do you have any sort of reason that can look like a realistic reason for why you're withholding payment? It can't be that you're out of money. It can't be that you don't like the guy. It can't be that you think like this is the way to make him work harder. It can't be something that doesn't have any legitimacy like that. It has to have some bearing in reality. And if it does, then you can withhold payment regardless of what the contract, you know? So that's one way that developers can kind of protect their budgets, but you have to watch out for the statutory problems that you might run into if you do that. That's progress payments. On final payments, what I've seen seems like quite often is there's usually a big buildup of retention throughout the project. The developer has been withholding retention from each payment application. And the owner is holding on to that. And if they've had a dispute with the contractor near the end of the project, it seems to me like they start seeing that and any leftover contingency as their litigation budget. So if there's $5 million to pay out in retention, right? And it only cost the owner, maybe $1 million to fight with the contractor about getting that $5 million, and they end up paying out 4 total. Well, they saved $1 million, you know? And especially if you hold the retention like that to the end of the project, the contractor doesn't have it for their legal budget, right? So there's games that you can play, but that also exposes you to those prompt payment violations. So if you do that and it's found that you're doing that in bad faith as a developer, and you're going to lose, you're going to get hit real hard, and there's a lot more money than you thought you might save if you're trying to actually play games like that.
So a couple of similarities or parallels, I guess. You're obviously providing services to developers and actual contractors that build things, but I am also considered a contractor. And I don't know if you would put yourself in that realm, but if you just look at the payment structure, attorneys are generally contractors.
Uh-huh.
So we all have our ways of protecting ourselves. And mine is one, work stoppage. And two, when I get to the end of a project, I withhold a little bit to make sure that my client pays as well. And that could be, if it's a small project, it might be withholding a final report and setting out a draft. If it's a permit, I am the one that has to turn in final permit documents or fulfill the final approval process with an agency. And I can make sure that I am pretty much paid up by that point, maybe with some residual left. So even if I did have to forego that final amount, it's not that big of a risk. So how does that play into how you look at construction contracts?
Yeah, that's a really good point. What you said at the beginning, it's slipping my mind right now.
Work
But
stoppage?
if you, what's that?
Work stoppage?
Work stoppage, exactly. So work stoppage is a great example of a powerful remedy that the contractor has during the project to encourage the owner to pay. So the clause that gets at that, and that is addressed in construction contracts. Typically, if you're on the owner's side, if I was negotiating a contract for the owner, what I'll try and say is, if there is a change order and we're disputing it, or if there's a dispute about payment, you continue to work until we resolve that dispute, or through resolving that dispute. So the dispute about payment is not a reason to stop work. And it's a flip if I'm representing contractors. So usually what I'll say is, then this usually comes up during change order. Like if there's a change order dispute during the course of the project, oftentimes the owner will say, okay, we didn't have this in the plans, but now we want this. Can you build that? The contractor will say, yes, will you send a change order? And the developer will usually say, oh yeah, I'll get around to it. Right. But if there's no signed change orders, then that doesn't increase the budget and the contractor is not going to get paid. Right. So because the parties are trying to work well together, the contractor will usually proceed with the work. And that's called at risk, because they don't have a change order or a contract essentially for that work. And if they don't get paid, what I put in the construction contract, if I'm representing the contractor, is that they can stop work if there's an outstanding disputed amount. So if the change order is supposed to be for $500,000 and they've, done half of the work, then they can, they can stop work after they've hit like $100,000 worth of work, something like that. Right. So you address that because I think that's a powerful way for the person who's supposed to get paid to get paid is to stop. And if you're the developer and you can't afford that because say you've got these tight deadlines and you've got um, a looming payment due, then you want to make sure that's kicked out. And I've seen that sometimes those things are at odds with each other because sometimes developers will be in a situation where they need the project to be finished to trigger the next round of funding. And then their plan is to use that funding to pay the contractor.
Oh yeah.
But by the time you've hit that end of the road of the project, if there's not goodwill, this just goes back to the relationship issue. The contractor is not necessarily going to be willing to believe you or accept that argument if you're a developer. Does that make sense? And this goes back to, since we're getting close to time here, I can't emphasize enough that a lot of problems when you trace it back as a lawyer, you get in litigation, you start looking through all the emails and text messages and correspondence. It usually comes back to a couple folks that have bad attitudes and could not have resolved their problems through talking about it. So, through a simple kind of emotional intelligence, lack of emotional intelligence, there ends up being multi-million-dollar problem. So if there's kind of one takeaway from this, it's work on your ability to have a relationship and talk things through. And that's well recognized, and some contracts try to implement that by what's called partnering provisions, where they literally have sessions scheduled for the executives to meet and sit down and talk things through. But those won't work if the people involved aren't emotionally intelligent or aren't able to talk things through. So you really got to find the project executives that have that ability to work with other people if you don't want your project to go over time and over budget.
Yeah. Makes sense. Well, I definitely am now thinking through my own contract. So thank you for that. Um, hey, I feel like we could definitely continue this conversation for a while, but we have a finite amount of time for today, and kind of want to wrap things up for both of our benefits. So, do you have kind of like a final summary that you would want to leave with a developer and or contractors that might be watching this?
Yes, definitely. For developers, I would say that you're in charge of there's a big responsibility that you have to bring something into the world that's supposed to be amazing. And I think that that's a privilege to have access to those ideas and the money to do something like that. And it's risky. It's a risk to do that. So accept that risk and approach a contractor as a partner, and don't have naive expectations about how much things cost or how long they take to build. So approach things in a collaborative mindset, rein in your attorney to make sure that they're not being too zealous. And I think that will help you get your project done on time. For the contractors, it's straightforward. It's get the job done, make sure you're out there. Similarly, make sure that you could partner with someone. Make sure that you have a project manager that's good at talking things through and is also good at making sure that folks are tracking things and getting their paperwork in on time. Because it's not the paperwork required in a construction project these days isn't just a bureaucratic nicety. It's often required for your partner, the developer, to get paid so they can pay you. So, be a good construction partner. That would be my high level summary for folks.
All right, very good. Well, hey, Greg, it was great to have you today, and who knows, we might call you back for some other conversation topics in the future. So,
Great.
nice to
I
see you
really
again.
appreciate it. Yeah.
Yeah, this is fun. So, thanks a lot, and have a great day.
All right. You too. We'll see you.